you don't want that evidence to show up in court, so you may request through a motion in limine that the defendant or the other side not bring it up. Or if you know that the judge will allow it to be brought up in a way that's the least prejudicial possible, that prevents that undue prejudice. So maybe bring it in writing instead of having someone testify with tears and all that stuff. Then of course you have the trial, and that can either be a bench trial or a jury trial. Again, a bench trial is one in which the judge decides both the law and the facts, so it takes the place of the jury. Or of course you have a jury trial where the judge deals with the law and leaves the fact finding, the determination of facts, to the jury. With a jury trial, you're going to have jury selection, where the attorneys get to pick their jury, basically. Of course, it's not handpicked. They don't get to fight until the last man to try to figure out, the perfect jury. Rather, they're trying to weed out bias or a couple of people that they may think are just not good for them. But it's limited. The trial itself, you're going to have, put this over here, you're going to have opening statements. You're going to have the plaintiff's case, the defendant's case, which is going to include in both of these direct questions, cross-examination, questions from the defense, and direct questions when it's the defendant's case, and cross-examination questions by the plaintiff. There's a possibility you'll see a motion for directed verdict. By the defendant at the end of the plaintiff's case, and by the plaintiff at the end of the defendant's case. The directed verdict, or motion for directed verdict, is basically, Your Honor, the plaintiff just rested and he didn't prove what he was supposed to prove. Because of that, why do we even need to go to a jury? There's no possibility that the jury can find in his favor because he hasn't even proven the facts that he was supposed to. Or likewise, at the end of the defendant's case, the plaintiff would say, Your Honor, let's get rid of this. This doesn't even need to go to the jury. It's so obvious. He didn't even put up a defense, and my proof, my evidence was airtight. There's just no way a jury could decide opposite of what's been presented. That's the motion for directed verdict. Then you'll have closing arguments, where the attorneys, each attorney gets a chance to put all the facts together. And I should specify that in the opening statements, the attorneys are not arguing. They are talking about what the jury will see, or what the judge will see, what evidence they will see, not arguing or not assuming that the facts have already been supported. The facts haven't been supported yet. In the opening statements, they're merely, it's like a table of contents. They're saying, well, you will see this witness testify, you will see this evidence, you will hear this person say something. You will hear this other person say something else. Whereas in closing arguments, you hear very simply, or you actually hear the attorney saying, well, you heard this, you heard that, you heard that. The only reasonable thing you can come from that is that he crossed onto the person's property. Or he said it himself, he crossed on the person's property. So we have to agree that that's the fact. Finally, if there is a jury, then charging instructions will be given to the jury to deliberate on the matter, and you'll get a verdict. If the defense loses, you'd likely get a request for a new trial, a motion for a new trial. Or in either case, you might have what's called a JNOV, which is a judgment notwithstanding the verdict. That request is basically asking the judge, you know what, when I asked you about that directed verdict, you were wrong. You should have agreed. You should have found in my favor. You should have given my request more thought. The judge can say, well, you know what? You're right. I should have ended the case at that point and found in your favor. So even though the verdict has been in, the judge is reaching back in time and saying, well, when you asked me for that motion for directed verdict, I should have agreed with you. And of course, when it comes to the trial stage and what we're going to talk about, the paralegals' duties rest here for the most part. You will have some, you will have some work in all of these stages, but discovery is by far the part that requires the most work. Okay, that's the end of reviewing Chapter 1 and Chapter 2. I'm going to post a discussion board, and I would like you to add a discussion on one thing that you found, at least one thing that you found interesting about this lecture, something you didn't know, something you'd like to learn more about, just something regarding this lecture. I want to see you put a fact on there, and it will be worth some points, so make sure you put in that information. You'll have until next Wednesday morning to do that. That's when the next video presentation will be available.